Hi, everyone. I'm Anna Nienhuis with We Need a Law, and I'm here with John Sikkema, who's legal counsel with ARPA Canada and the Director of Law and Policy. And ARPA Canada is the campaign that oversees We Need a Law, and they're the ones who are involved challenging the decision to reject a bus ad of ours in the city of Hamilton in Ontario. So I just have John here today to talk with me a little bit more about that. Thanks, John.
Yeah, good to join you.
So the first thing I just want to kind of go over for our supporters, because sometimes we do these court cases, these legal challenges, and we just kind of give updates once every 6 months or a year, but they can be kind of this long process. So I want to talk about what that looks like and why we think it's worth doing. So first of all, can you just give us a bit of background on this case? Like, who was involved? When did it start? What happened?
So in 2020, a member of Parliament, Kathy Wagenthal, introduced a bill to ban sex-selective abortion. That's one of the things that We Need a Law had been pushing for through its Defend Girls campaign, as you know. And so the ARPA Hamilton chapter tried to take out a bus ad in Hamilton to support that bill. And the ad, as people can see, says, "We're for women's rights," and then has some pictures of women at different ages, ending in an ultrasound image. And it says, "We're for women's rights, hers, 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 hers too." And Hamilton took quite a long time to review that ad to decide whether it could go on its buses or not. And after a couple of months, Hamilton responded and said that the ad was misleading because using the pronoun hers in reference to a preborn child implies that the child is human. And according to the criminal code on homicide, a person becomes a human being, again, for the purposes of homicide law, when they're born, right? And so because in law, the child's not a human being, you can't imply the child is a human or a person in your ad. That was the city's somewhat convoluted reasoning, but that was why they rejected the ad. John Bucke of the Hamilton chapter tried to engage with the city, replied to that saying, this isn't really good reasoning. This certainly not a legal problem with this, or the ad doesn't actually mislead anyone as to what the criminal code says. And the city basically, again, took some time and reiterated the same reasons. We're not running this ad. It misleads people. It implies that the unborn child is human.
So that's where John contacted not you, John, but the other John then contacted you or contacted ARPA to say, hey, the city's decided not to run this ad. They're rejecting it, and this is why. And that's where we got involved.
Yeah, that's right. So there were 3 responses from the city of Hamilton saying we're not running this and just repeating the same reason. And so that's when ARPA Canada and ARPA Hamilton, through John Bucke, took Hamilton to court. And that goes to what's called the divisional court. It's a constitutional court. That is, it can make constitutional rulings. It's a panel of 3 judges, and that court reviews decisions of administrative agencies. The Human Rights Tribunal, let's say, if you appealed from them, it would go to that court, the divisional court, and decisions made by cities and other government entities also go to divisional court. So we took the decision of Hamilton to the divisional court to review that decision.
Okay, yeah, and it was a really interesting decision. Like you said, it was not great reasoning because, I mean, we all know that people find out the sex of their baby based on ultrasound technology. We know that people do gender reveal parties based on getting that information from ultrasounds. So to refer to an ultrasound image as hers, in terms of our culture, makes a lot of sense. People would definitely understand what that means, and that's a realistic understanding of what we're seeing in the womb. So when that reasoning came through, then obviously we thought, okay, they're challenging it based on the fact that this is a pro-life ad. So that's where the challenge to the court went in, to say, hey, this is our freedom of expression to also share the pro-life view, and that's why we're going to take the step of actually taking this to court. So then we went to court with Hamilton. So you said this was 2021. So that's 3 years ago now, so quite a while. So that all takes a lot of time. So then it went through the court there, and what did they decide in the end?
So the court decided, actually, the week before the court hearing, so it took us a couple of years to get there, but the week before the court hearing, Hamilton sends basically a 1-page submission to the court saying, we didn't talk about ARPA's freedom of expression in our reasons our reasons for rejecting the ad, and we should have. So please send it back to us so we can talk about freedom of expression. And the court picked up on that and said, well, indeed, you didn't talk about their freedom of expression. Now, Hamilton had legal advice. They actually told us they got legal advice in reviewing our ad and deciding to reject it. So we pointed out to the court that, of course, Hamilton would have thought about freedom of expression. We obviously, in not running our ad, that's obviously limiting our freedom of expression. But anyway, the court said, you haven't talked about their freedom of expression. You haven't justified your decision to reject the ad. So in other words, the court saying the decision to reject the ad wasn't adequately justified. The court orders Hamilton to pay us $20,000 really because it's, the city has failed here. But the court doesn't do what we really hoped the court would do, which is review the kind of substantive reasoning for rejecting the ad. So under Canadian law, when a court reviews a government body's decision, yes, they review it, was it legal? Was it constitutional? Yes, but they also review it for basic reasonableness. The court's going to look at, is the decision and the reasons given for it coherent, logical, in a very, very basic sense. And we had argued that it failed even to reach that. So even before you get to kind of the grand constitutional issues and what have you, that arguing that this ad misleads people by implying the unborn child is human is incoherent reasoning. In fact, the city tries to rely on the criminal code for that, right? And we pointed out, well, the criminal code itself actually refers to unborn children as children with the term child, right? Which again implies humanity. The criminal code's not making a metaphysical, philosophical, or any such point when it defines human being. It's setting the law of homicide versus what used to be the law of infanticide and the law of abortion, right? These are technical reasons. They're not saying people in society can't disagree on when life begins. Anyway, I think the court doesn't comment on that one way or the other. But later on, Hamilton, down the road, Hamilton actually seems to drop that line of reasoning, which is encouraging to me.
Yeah, it's interesting that they seem to realize they weren't going to get anywhere with that. So it's still such a long process, though, for in the end, the city of Hamilton to say, yeah, we were wrong. But at the same time, it's a win because now they are going to run the bus ads. So basically, they've decided we didn't have good enough reasoning, but they were made pretty clear in their ruling too. You had said that they weren't very happy about it. Like they didn't really want to make this decision. So it's great to see that they did. But I think it also, moving forward for us, we think this isn't a really solid win in that we're like, all cities will now have no problem recognizing freedom of expression and posting pro-life ads. So kind of where do we go from here? How do we keep defending and preserving this freedom that keeps being under attack?
Yeah, so I think on the one hand, it's a good precedent in that, if another city were to reject a "we need a law" ad or a "defend girls" ad, we could point to this case and say, look, this city did this. They lost in court. They ended up running the ad, right? So we can point to all those facts in the court judgment that we have, but yeah, what we don't have is a court judgment to point to where the judge actually goes through, here's the justifications that Hamilton used and why they're nonsense. That would be a much stronger ruling, of course, but it's still better. It's still better than nothing, and it is in the end a victory. But yeah, Hamilton, even after the court said, you need to reconsider this decision, you need to give better reasons. Hamilton could have tried to justify rejecting the ad again, right? So the fact that they didn't, I think, means that they thought their reasons weren't that strong. Like I said, they dropped, they give us a new written decision saying we will run the ad. We have some problems with the ad. They don't really specify exactly what those problems are. They don't allege that it's misleading anymore. But anyway, so in that sense, I think this does help us, obviously with the city of Hamilton, but with other cities as well, to keep running these ads. And I think, we might get another city that is, bold to reject an ad like this, and that might be another opportunity to for us to get a court to review the reasoning that's often used. And one of the problems is it's not only used by cities, and you can take cities to court. Sometimes it's used by Ad Standards Canada when you're trying to advertise through private billboard companies. Ad Standards Canada is a private body, and they'll say, we find this ad misleading. This reasoning actually kind of originates there. And then there's it's a little trickier to deal with that, because you can't have a court review their decision like you would a government body decision, and the charter doesn't apply to private billboard companies, right?
Right, and we have had issues with that in the past. So then being able to work with cities gives us a bit more flexibility to actually engage those constitutional rights more intentionally. So that's cool.
Exactly. Yeah.
But thanks for all your work on this. Like I said, it's like a 3-year process, so it's not that you can just file a challenge and be done with it. So we appreciate all the work you did on behalf of ARPA and the ARPA chapter, and for the We Need a Law ad. And I think as We Need a Law, I just want to mention too that it's something we're going to continue doing. We always say it's a freedom we need to use so that we don't lose it. So continue putting bus ads in different cities. We always have, with our different campaigns, we have graphics designed for billboards and bus ads so that local supporters who want to put an ad in with their city can submit those ads. We have them ready, and if a problem like this comes up, they're welcome to contact us and have us help them walk through the process of either dealing with a rejection from a city, or kind of giving some reasoning to a city, or if a court challenge is needed, then considering that. So We Need a Law will continue to put out pro-life ads and continue to fight for that freedom of expression to share the pro-life view. Did you have anything else you wanted to share about the case, or?
Yeah, just thanks to ARPA Hamilton. I think it's great that as a chapter they took the initiative to run the ad, and like you said, other chapters can do the same. Keep these campaigns going.
Absolutely. Okay, thanks so much, John.
Thank you.